All right, Florida Department of State, Division of Corporations, Florida Trademark Service Mark Registration and Use. Division Corporations, P.O. Box 6327, Tallahassee, Florida 32314. Forward, the Division of Corporation, Florida Department of State produces the booklet specifically for the convenience of those who frequently refer to Chapter 495 of Florida State Statutes. All history notes commonly found in Florida statutes have been omitted. The booklet is not an official published version of Florida statutes and is not intended to be considered as such. The forms, instructions, are registered, cancel, renew, and assign trademark services are printed in the back of this book. We hope this publication will help you with filing the Division of Corporation. Division of Corporation, internet address www.sunbiz.org, mailing address P.O. Box 63127, Tallahassee, Florida 32314, street address Clifton Building 2661, Executive Center Circle, Tallahassee, Florida 3230441. Alright, the table of contents, Chapter 495, Florida State Statutes, forms of registration, trademark services, forms of renewing trademark service marks, and forms of assigning trademark service marks, forms of canceling trademark service marks, forms of changing names, registrations, trademark service marks, and division corporation telephone directory and internet address, page 34. Alright, is in 495. You have the short title definitions, registratable application, registration, and final application to use of related companies, disclaimers, certificate of registration, duration, renewal, assignment, change of the names, security interests, records, cancellation, classification, fraudulent registration, infringement, remedies, form of actions regarding registration, dilution, common law rights, effective date, and replaying of conflict of action, construction of chapter, and fees. 495.01. Short title. This chapter may be cited as Registration Protection of Trademarks Act. 495.011. Definitions as used in this chapter. Abandon applies to the mark that either from the following occurs. When it is used in disconnect with the intent is to resume such use. Intent not to resume use may be inferred with the circumstances non-use for 3 consecutive years shall constitute prima facie evidence of abandonment. B. When any of the course of the conduct of the owner includes the act of omission, the commissions which cause the mark to lose significance as a mark. 2. Application means the person filing for the application registration mark under this chapter. Legal representative successors assigned such to a person of such a person. Certification mark means of any word, name, symbol, device, or combination thereof used by a person then other than the owner of the mark to certify the regional and their original material, mode of manufacturing, quality assurance, and other characteristics of such a person, goods, services, or that will work on labor on goods for services performed members of a union or other organization. Collective market means a trademark service mark used to the member of cooperative associations. Other collective group of the organization includes marks that indicated by the membership in the union and association or other organization. Department means the Florida Department of State or is designee charged with the administration of the chapter. 6. Dilution means the lessening of the capacity of the mark, identifying distinguishing goods or services regardless of the presence or of absence of A. Combination between the owner of the marker and the other parties. B. Likelihood of confusion, mistake, and deception. 7. Mark includes the trademark, service mark, and certification marks. The collective mark entitled with the registration under the chapter where they are not registered. 8. A person, any other word used to designate an applicant or other party entitled with the benefit of the privilege rendering liability under the provisions of the chapter means a juristic person as well as the nature of the person. Juristic person includes firm, partnership, corporation, unit, and association or other organizations capable of being sued in a court of law. 8. Registration means that the person to whom the registration of the mark of the chapter is used, the legal representative successor assigns to such person. 10. Related company means if any of the person who using the mark are controlled by the owner of the mark with respect to the nature and quality of the goods or services, the connection with which the mark is used. 11. Service mark means for the word or name of the symbol, device, and combination thereof, and by a person identifying the distinguishing of the service of such person, including a unique service from the service of others, indicating the source of the services, even the source is unknown. Titles in the charter names, other distinctive features of the radio television programs may be registered service marks, notwithstanding the person or the program may be advertising goods or sponsoring. Trade name. The means of any name used as a person to identify the business or vocation of service such a person. 13. Trademark means of any of the word, name, symbol, devices, combination thereof used as the person to identify the distinguish of the goods of such a person, including the unique product from which the manufactured by the sold or by others to indicate the source of the good, even though the source is unknown. 14. Use may be a bona fide use of the mark in ordinary course of trade, not only to merely propose the reserving of the right of the mark. For the purpose of the chapter, a market may be deemed in use of A. On the goods, the mark may be placed on the manner of the goods, the containers displayed and associated therewith, or on the tags, the labels affixed to, and if the nature of the goods makes such a placement impracticable of the documents associated with the goods and on their sales. The goods are sold and transported in the state. B. On the service with the mark or displayed on the sales advertising the service for the services rendered in the state. 485.21. Registratability. 1. A mark with good services for any of the application registration may be distinguished from the good of the service that others shall not be registered. A. By the consistent, compromising, moral, deceptive, or scandalous manner. Consist of a compromising matter which may be disparaging, falsely suggested connection with a person, living or dead, institutions, beliefs, national symbols, bringing them into the contempting and disrepute. C. Consists of the compromise of a flag or coat of the arms other than the insignia of the United States or of any of the municipalities or any of the foreign nations or any similarity thereof. D. Consists of the compromising of a name and signature and portrait identifying the particular living individual except for his or her written consent on the name and signature portrait deceased by the President of the United States during the lifetime of his widow or her widower. If any except the written and consistent with the widow and widower. E. The consistent of the mark which, 1. When used in or in connection with the goods or the services of the application is merely descriptive and deceptively misdescriptive of them. 2. When used on or in connection with the goods or services of the application is primarily geographic and descriptive of them. 3. When used in connection with the goods and services of the application primarily geographically deceptively or misdescriptive of them. 4. Is primarily merely a sure name. 5. The compromise of any of the matter of the whole is functional except for the expressly excluded with subparagraph 3 and 5, noting the subparagraph shall prevent the registration as marked by the applicant, which has distinctive for the application's good or services. The department may accept the prima facie evidence that mark that has been distinctive as used in the connection with the application's good or service as proof of the substantial, exclusive, and continuous thereof of the mark of the applicant. In this state, elsewhere, for 5 years before the date of the claim distinctive is made. F. Consists of the compromise marked with the resemblance of the registered state and the mark of the trade of the previously used in the state by the another or not abandoned is likely to be when and applied to the goods and services of the applicant to the cause of confusion and mistake of the deceive. Registration shall not be denied solely on the basis of reservation or registration by another of corporate name or fictitious name that is in the same or similar mark of the registration sought. Subject to the provisions relating to the registration of the trademark services marks so far as the applicable collective certification marks, including indications of regional origin, shall be registered under this chapter in the same manner with the same effect of the trademark services marks by the person, nation, states, municipalities, and like any exercising control over the use of the marks sought by the registered, even though the processing of the industrial commercial establishment and when registered, they shall be entitled with the protection provided with the chapter. In this case, the trademark and service marks, the Department of State may establish a separate registration with the collective marks and certification. 495.031. Application registration subject to limitations set forth in this chapter. Any person with the trademark subject to the mark in the state of the may file and with the department in the manner with complying with the requirements of the department application of the registration for the mark set forth, but not limited to the following: the name of the business address of the person applying for such registration, if the business at any place is incorporation or organization. B. The goods and services or the connection which marketing is used in mode of or manner in which the market is used in connection with such goods, services, and classes or are the classes in which the such goods, services fall in. The date of the mark when first used anywhere, the date was first used by the state, and the applicant, predecessor, interest related with the company of the applicant, the statement of the applicant of the owner of the mark is in use, that the best application knowledge, no other person except for the related company has registered such mark in the state, the right to use such a mark in the state, either identical, therefore, of the nearest resemblance thereto to be likely when they applied to the goods and services of such other persons to cause confusion, to cause mistake, or to deceive. 2. Every application for the registration, certification, mark of the state shall file with the department in a manner, form, and complying with the requirements of the department in an application set forth and not limited to the following information. A. Information required by paragraph 1A. The date of the certification mark was first in use anywhere with the date was first used in the state under the authority of the applicant. The manner in which any of the conditions under which the certification mark is used in the state of and 4. D. A statement of the application exercising control over the use of the mark. The applicant is not him or his or herself or himself engaged in the production of the marketing of the goods and services to which the mark is applied, but no person except for the application of the person is authorized by applicant related to the companies thereof the right to use such a mark in state either by the identical form thereof, the near the resemblance thereto as be likely when applied with the goods and services of such of other persons to cause confusion and to cause mistake or deceive. 3. Every application, registration, collective mark in the state shall fill within the department and in the manner that complying with the requirements of the department applicant set forth, but not limited to the following information. The following the info required in paragraphs 1A and B. The date of the collective mark was first used and anywhere the date was first used in the state and member of the applicant or the related company in such a matter. The class of persons of the entitled with the use of the mark indicating with the relationship with the applicant, the nature of the application, control over the use of the mark. A statement no other than except of the applicant, members of the applicant related to the companies thereof, the right to use such a mark and in the state after either by the identical form thereof and in such resemblance that thereto be as likely when applied to goods and services such other persons to say it cause confusion, cause mistake, or to deceive. The department may also require the drawing of the mark, complying with the requirements of the department and accompanying with the application. Every application under this section shall be signed, verified by application or by a member of the firm, officer, and other authorized represented business at any applying. Every application under this section shall be accompanied by 3 specimens, facsimiles showing that the mark is actually used. Every application under this section shall be accompanied by a filing fee payable to the department in accordance with 45 and 1091. Filing of the application. Upon the receipt of the application, the registration payable with the application fee, the department may cause the application to be examined for the conformity of this chapter. The application should provide additional information requested by the department, including the description of the design mark, any mark, make authorizing the department to make such an amendment. Such amendments to the application may be reasonably requested of the department deemed by the applicant by visible to the respondent of the rejection. Objection, the department may require the application to disclaim unregisterable content of the mark, otherwise registrable, and applicant volunteer disclaimer component with the mark stuff to be registered. No disclaimer shall be prejudiced affecting the applicant's registration rights and the existing thereof after the disclaimed matter and application of the registration of the rights on another application if disclaimed. Matter is or has become distinctive of the application of registration good of services. For the amendment may be made with the department of the application submitted with the application. Upon the application agreement, the new application may be required to submitted with the amendments otherwise than properly filled with the filed with the application shall not be effective with the application filing date of the purpose of determining the application's registration filing priority rights. 5. If the application should not be entitled with the registration, the department should advise the application of the rejection of the required reason for the rejection. The application shall have 3 months with the reply with the amendment with the application in which either the application be re-examined. The procedures may be repeated until the department makes final refusal to the registered mark. The application fails to amend the application with a specified period whereupon the applicant is abandoned for the good cause such a dependency litigation involving the mark. The department may extend the period of time which responds to the rejection and suspended examination of the application. If the department makes the final refuse the registration mark, the application may seek review such a decision in accordance with the 12 statute 12 5069 or 125.7. In an event with the primary application concerns concurrently being processed by the department, we seek registration of the same confusing similar marks and the same related goods services. The department shall grant priority to the application and order the receipt. If the priority received application is granted for the registration, other applications should be rejected. The application rejected applications may bring an action of cancellation registration upon the grounds of the superior rights of the mark in accordance with the provisions. 49504, using related companies. When are the mark registered, unregistered, is or may be used legitimately by related companies, such shall be in the benefit owner of the mark, and such shall have not been the validity of such a mark registration provided with such mark is not used such a manner to deceive the public, even if the first use of the mark of the person controlled by the registration application of the registration of the mark with respect to the nature quality of the goods and services such as the first shall inquire to the benefit of the registration of the applicant that there is to be a case. 495.051 disclaimer. The Department of State may require the application of the registration to disclaim the unregisterable component of the mark, otherwise registratable. On an application may be voluntarily disclaimed component of the mark shall be registered. No disclaimer shall be prejudiced affecting the application registration right with the existing. Therefore, the arising from the disclaimed matter of or his or her or his right the registration on another application, if disclaimed by matter, shall have become distinctive to of his or her goods or services. 295.061. Certification, registration, and compliance with the application requirements of this chapter. The department shall cause the certification registration to be issued, delivered to the application. The certificate registration shall be issued in the signature of the Secretary of State, seal of the state, and if you shall have the name of the business address and the business entity placed within corporation, organization, person claiming the ownership of the mark of the state, the date claimed for the first use of the mark, anywhere of the date claimed for the first use of the mark in the state, the class of the goods and services, description of the goods and services in connection with the mark and the reproduction of the mark, registration date, and the term of the registration. 2. Any certification or registration issued by the department under the provisions hereof, the copy therefore of the duly certified by the department shall be admissible in evidence component with the sufficient proof of registration of such mark, that any action of judicial in proceeding in a court of law and state shall be prima facie evidence and validity of the registration ownership of the mark and the registration inclusive rights of the mark and the state of the connection of the good services specified with the certificate subject to any conditions and limitations stated therein. 495.071 duration renewal registration of the mark here under the shall be effective within the term for the 5 years of the date of the registration upon the application filed with 6 months prior to the expiration of the date of such term in the manner of complying with the requirements of the department. The registration renewed from the like term being in the end of the expiring term, that each of the application under the section shall be accompanied by filing fees payable to the department in accordance with the statute 495.191. Any registration may be renewed successful periods of 5 years in like manner. Any registration in effect after January 1st, 2007 shall continue in effect an unexpired term thereof and then be renewed filing with the application renewal with the department in the manner for the complying with the requirements of the department, paying the renewal fee thereof within 6 months prior to the expiration of the registration. For all application renewal under the chapter, the registration made under the act of the registration may be made under any of the prior acts shall be include the verified statement of this mark and still had in use of the state still include a specimen showing actual on the mark of the connection with the goods and services subject to the renewal application shall state the non-use of the deal due in special circumstances which excuse and non-use and not due any intention of abandoning the mark. Alright, 495.081. Adjustments, change of the name and security interests is a registered mark for which an application registration has been filed, such as assignable for the with goodwill with the business in which the mark is used, and whether the part of the goodwill is based on the connected with the use of the symbolized by the mark. Assignment shall be instrumented with the writing duly executed by may be recorded with the department upon the payment of the applicable fee. A photocopy of the assignment shall be accepted with the recording and is certified to any of the parties thereto of the successor to be true of the correct copy of the original. Upon recording the assignment, the department shall issue the name of the assigning with the new certificate. For the remainder of the term of the registration and the last renewal thereof, the assignment of the registration under the chapter shall be voided against in subsequent chat purchases. Valuable consideration within the notice unless the as such assignment is recorded with the department within 3 months after the date of the assignment prior to the subsequent purchases. 3. Registration. Application registration affecting the change of the name of the recorded if certified with the change of the name of the registration. The department upon the payment of the recording fee payable to the department in accordance with statute 495-191. In the case of pending of the application may comes approved, the registration department shall issue a certification registration news and the new name and the registered mark. The department shall issue the new certification registration and in the registration the new name remainder of the term of the registration last renewal thereof. The person required for the record of name change in accordance with the subsection shall not affect the person's substantive right to mark the registration. Acknowledgement shall be prima facie evidence of the execution as an assignment other than an instrument recorded by the Department of the Record shall be prima facie evidence of execution. Security interests in the acts of the breach shall be created with the perfected in accordance with statute, chapter 679. 495-091. Record. The department shall keep the record per public examination record for all marks registered and renewed under this chapter, including all documents recorded under statute 495-81. 495-105, cancellation. The department shall cancel registration any registration of the department that has received voluntary request, cancellation registration request in the manner of complying with the requirements of the department. All registration granted under this chapter be not renewed in accordance with the provisions. Any registration for which the court of the competent jurisdiction finds that A, the registered mark has been abandoned, the registered is not the owner of the mark, the registration was granted improperly, the registration is obtained frequently. The registration was obtained fraudulently. E. The mark has become the generic name for the good of the service and their portion thereof for which the mark has been registered. F. The registered mark is so similar but likewise the confusion, mistake, but deceive the mark of registered or any other person in the United States Patent Trademark Office prior to the date of the following application registration here and under the abandoned however shall registration prove the registration owner of the current registration is marked on the United States Patent Trademark covering the area that the state of the registration here and under shall be canceled. G. In any case, if the certification mark with the registration does not control and is not being exercised control over such a mark engaged in the production, marketing, and any of the goods and services with the certification mark is applied, or the registration permits the certification mark for the purposes other than certifying registration discriminately refuses to certify continue to certify the good of service of any of the answers maintaining the standards or conditions which shall have which such marks certify. Nothing in the subparagraph shall be deemed prohibited the registration from using the certification mark in advertising, promoting recognition of the certification program, and of the good of the service meeting the certification standards of the registration. 4. When the court competent jurisdiction shall be other than cancellation registration goods. 495-111. Classification. The following general class of the good of the service conforming with the classification adoption. United States Patent Trademark Office established the conveniency administration of this chapter. Goods. Class 1. Chemicals used in industrial science and photography, agricultural, horticulture, forestry, unprocessed artificials, resins, unprocessed plastic, manures, fire extinguishers, compositions, tempering, soldering, preparation, chemical substances, preserving, foodstuff, tanning substances, adhesive in the industry. 2. Classing of paint, varnish, lacquers, preservatives against rust, against deterioration of wood colorants, moderates, raw, natural resins, metals, and foil powder for painters, decorators, printers, and artists. Class 3, bleaching preparations and other substances, land The laundry use, cleaning, the polishing, securing, and the abrasive preparation, the in-soak, performing an essential eye oil, cosmetically, and hair and lotions and dentifrice. Class 4, industrial oil, grease, lubrication, dust absorbing, wetting, and the binding of the composition fuels, including motor spirits and illuminations, candles, and wicks for lighting. Class 5, pharmaceutical, veterinary preparation, sanitary preparation for medical purposes, dialectical substances that hit after the medical use in the for and food for babies, plaster materials for the dressing material, and stopping the teeth and dental, wax, disinfection preparation, destroying verminal and fungicide and herbicide. Class 6 common metals that allow with the metal building materials, transportable buildings, metal of the materials with metal of the railway tracks, non-electrical cables, wires, common metal, and not iron monogamy, small items, metal hardware, pipes and tubes, and metal and stuff is safe as good as the common metal used in any other classes or ore. Class 7 machine and tool motors, engines, except for land vehicles, machine coupling and the transmission components, except for land vehicles, agricultural implements, other than hand operated, incorporated for eggs. Class 8 hand tools, hand operated with the implementation, culture, sidearms, and razors. Class 9 scientific and nautical surveying, photography, cinematographic, optical weighing, measuring, signaling, checking, supervision, and life-saving technique apparatus, apparatus instruments for conducting, switching, and transforming, accumulating, regulating, and controlling electricity apparatus for the record of the transmission, reproduction of sound, images, magnetic, and the data of the carrier's record disk, and automatic vending machines and mechanism for the coin-operated apparatus such as register and calculation. Machines and data processing equipment, computers and fire extinguisher apparatuses. 10. Class 10. Surgical metal, dental, veterinary apparatus, instrument, artificial limbs, eyes, tooth, orthopedic articles, and suture materials. Class 11. Apparatus of lighting, heating, and steam, generating, cooking, refrigerating, dyeing, ventilating, water supply, sanitary purposes. Class 12. Vehicles, apparatus for locomotion by land, air, and water. Class 13, firearm, ammunition, projectiles, explosives, and fireworks. Chapter Class 14, prestigious metals and alloys good with the prestigious metals coated with the not included in other classes, jewelry, precious stones, horological and chronological metric instruments. Class 15, musical instruments. Class 16, paper and cardboard goods made from the materials not included with the other classes, printed material, bookbinding material, photographs, stationery, adhesive, stationery, household purposes, artist materials, paintbrush, typewriters, other requisites except for furniture, instructional teaching material except for the apparatus place materials for packing and not included with the other classes, printer's type and the printer blocks. Class 17, rubber, gata, peach, percha, gum, asbestos, mica, good made for these materials not included in the other classes. Plastics exclude the manufacture, packaging, stopping, and exalting materials, flexible pipes, not on metal. Class 18, leather, eliminations, goods made for the materials not included in other classes, animal skins, hide trunks, travel bags, umbrellas, parasols, walking sticks, whips, harnesses, and soldiery. Class 19, building materials, non-metallical, ridge pipe for the building, asphalt, pitches, and the bitumen, non-metallical, transportation, buildings, monuments, and not for the metal. Class 20, furniture, mirrors, and picture frames, goods, and not included in the other classes are the wood, reed, cane, wicker, horn, bone, ivory, whalebone, shell, amber, mother of pearl, and or mercamum, substituting for all materials. Class 21, household, kitchen utensils, containers, not precious metal, coated with air of combs and sponges, brushes, except for the paintbrushes, brush making materials, article, clean purposes, steel, wool, unworked, semi-worked glass, except for glass used in buildings, glassware, porcelain, either earthware not included in rope classes. Class 22, rope, string, nets, tents, wings, tarpaulin sacks, sail sacks, bags, not including others, padding and stuffing materials except for the rubber and plastic, raw, fibrous, textiles, materials. Class 23, yarns and threads of textiles. Class 24, textiles goods not included in other classes of beds and table covers. Class 25, clothing, footwear, and headgear. Class 26, lace, embroidery, ribbons, braids, buttons, hooks, eyes, pins, needles, and artificial flowers. Class 27, carpet, rugs, mats, matting of the linoleum, other part materials covering the existing floors from wall hangers, not textiles. Class 28, games, playthings, gymnastics, sporting articles not included within these class. Decoration for Christmas tree. Class 29, meat, fish, poultry, game, extracts, preserved, dried, cooked fruits, vegetables, jellies, jams, compotes, egg milk products, and edible oil fats. In Class 3, coffee, tea, cocoa, sugar, rice, tapioca, soya, artificial coffee, flour preparation made with cereal, bread, pastry, confectionery, ice, honey, and the tractile yeast, making baby powder, mustard, vinegar, and sauces, spices, and ice. Class 31, agricultural, horticultural, forestry products, grains, not included in other classes, live animals, fresh fruit, vegetables, seeds, and natural plants, flowers, and food stuff for animals, and malt. 32 class 32 beers, minerals, saturated waters, other non-alcoholic fruit juices, syrups, and other preparations of making beverages. Class 23 alcoholic beverages except beer. Class 34 tobacco, smokers, articles, matches. B class 55 advertising, business management, business administration, office functions. Class 35 insurance, financial affairs, monetary, real estate affairs. 37 building, construction, repair, installation, service. Class 38 telecommunications. Class 39 transport, packaging, storing goods, and traveling arrangements. 6 class 40 treatment of materials. Class 41 education, providing with the training and entertainment, sport, construction, and sporting cultural activities. Class 42, specific technology service, research design relating to industrial analysis, research services, design, developing the computer hardware, software, and legal services. Class 43, services providing with the food and drink, temporary accommodation. Class 44, medical surveys, veterinary service, hygienic, beauty care of the human beings, of the animals, agricultural, horticulture, and forestry services. Class 45, personal social services rendered to other meetings of the needs for the individual. Security services for the protection of property of individuals. Certification collective memberships marks. Class 200 collective membership marks. Class A certification marks of goods. Class B certification marks for goods. The goods servicing reset of collective trademark collective services. Mark applications are assigned to the same class for the appropriate for the goods in the general. The establishment of the class of the goods and services set forth in subsection 1 of the note, the non-purpose limitation exceeding the right of the application registration. A single application with the registration of the mark may include any of all goods upon which services in which the mark actually being compromised in one or more classes listed, but in the event of the single application includes good services in connection with which mark is being used to fall in with different classes of goods, services, and fee of equaling sum of fees and registration in each class shall be payable. 495-121 fraudulent registration. Any person who shall for his or her on her only behalf any other person procure filing and registration any mark of the Department of State under the provisions knowingly making the false fraudulent representation of the declaration verbally or unwritten or maybe writing or any other fraudulent means shall liability be paid all damages sustained in the consequential such filing registration for the punitive expiatory damages recovered on the behalf of the party injured by the court of jurisdiction. Alright, 495-131, infringement, subject to provision 491-461. Any person shall, without consent with the registration, use of reproduction, counterfeit copy of the colorable imitation of the mark registered under the chart of the connection with the sales, offering with the sales, distributed, or addressing, advertising the good of the service in connection which was used and likely to the confusion to cause a mistake to deceive. Art reproduces counterfeit copy to the colorability and imitate the market registered under the chapters applied with reproduction, counterfeit, copy, colorable initiation, label, signs, print packages, wrappers, receptacles, advertising intended to be used in connection with the sale, distribution, advertising, cool goods and services on the connection which such likely can cause confusion and cause mistakes and deceit shall be liable of civil action with the owner and registered from any of and all remedies provided within the statute 495 for 141 except for the other subsections. So under subsection 2, here the registration shall not be entitled to recover the profits and damages unless the action has been committed with the knowledge of such mark intended to be used to cause confusion or mistake or deceive. 495 4141. Any owner of the mark registered under this chapter that proceeds the suit enjoining the manufacture, display, the sale of any of the counterfeits, limitations thereof, and any of the court competent with the jurisdiction of the grant injunction, unctions, registration of the manufacture, display, sales, may be the sale at said court, and its deemed justice responsibility may require the defendants to pay to such owners all profits derived from all of the damages suffered by the reason of such wrongful manufacturer used display and sale to pay the coats and the actions as such of the court may also order that they any of the counterfeits in the imitation of the possession under the control of the definite defendant and such delivered into the officer and of the court the compliant should be destroyed. Assessing the profits of the plaintiff shall be required to prove the defendant's sale only. Defendants must prove all elements of the cost and deduction claimed. In assessing the damages, the court may be a judgment in accordance with the circumstances of the case for any sum above the amount found when the actual damages not exceeding 3 times such amount. If the court shall find the amount of the recovery based on the profile's profits is either inadequate, excessive for the court, and in its discretion, either the judgment for the sum of the court shall find it be just according to the circumstances of the case. Sum of the sum is either above the circumstance constituting the compensation, not a penalty. The court may also be awarded reasonable attorney's fee for the prevailing part according to the circumstances of the case. The enumeration of the any right remedy herein shall not be affect the registration's right to prosecute under circumstances of the case or under the penal law of the state. 495-145, form of actions regarding registration. Action seeking consolidation registration of a mark registered under the chapter which may be brought in many of the court competent jurisdictions in the state. Service processing, non-resident registration may be made in accordance with statute 48-181. The department shall not be made in party of the cancellation proceedings. 49-151, dilution. The owner of the mark famous with the state of the entitled with the subject of the principles of equality, and upon search to determine the court deems the responsibility injunction to obtain such a relief on and against another person's commerce will use the mark of the trademark name, and if such bringing it after the mark has been being famous is likely to cause dilution distinctive quality of the famous mark and provided with the same section determine whether the mark is distinctive and famous of the court and may be considered the factors including but not limited to a the degree of inheriting and acquired with the distinctive of the mark in the state, b the duration extent of the mark and the connection with the goods and services to which the mark is used, the duration extent advertising publicity in the mark of the state, geographical extent of the trading area in which the mark is used, e the channels of the trade of the goods services within the mark is used, the degree of recognition with the mark of the trading area channels, trade in the state with the mark owners of the person against whom the injunction sought. G. The nature and extent of the use of the same similar mark in the third parties whenever the mark is subject to the state, the registration of the state and federal registration under the Federal Trade and Mark Act of March 3rd, 1881, and the Federal Trademark Act of February 20th, 1905. Principal registration under the Federal Trademark of the Act of July 5th, 1946. An action brought under the section under the famous mark that shall be entitled only to injunction relief in the state unless the person against the injunction relief is sought willfully intended to trade the owner's reputation to cause dilution of the famous mark, if and such will intend to prove the mark registered in the state, the other shall be entitled to remedies set forth by the chapter, and so the discretion of the court of the principles of equity, the following should not be able to action under this section for use of the famous mark any other person cooperative in commercial address, advertising, promotion, identifying with competing goods and services owned with the famous mark, non-commercial use of the mark, all forms of new reporting and news commentary. 495, 161 common law rights not adhering within shall adversely affect the rights of the enforcement of the right and the marks acquired with good faith in any time of the common law. 495, 171, effective date repealing the conflict. The chapter of the bend with this act shall be enforced with the take effective of the January 1st, 2007. Shall be not in effect with any seat of the proceeding with the appealing with the pending. Section 50606 and 506 through 50613. Repealed January 1st, 2007, provided that any of the suit and proceeding with appeal with the purpose of any of the pending of this time in the chapter be amended by the Act, takes that such repeal should be deemed not to be effective with the final determination of said by the pending suit and proceeding appeal. 495.81 Construction of the chapter. The intent of this chapter to provide with the system of the state of the trademark registration protection substantially consistent with the federal system of the trademark registration protection under the Trademark Act of 1946, as amended, and to the extent of the construction given in the federal act that they should be examined with the persuasive authority interpreting and construing in this chapter. Fees and file 495 191. Fees. Filing other applicable fees payable to the department under this chapter shall be known as follows. Application fee is $87.50 per class. Renewal application $87.50 per class. Assignment filing fee $50 per $50. Certification of names and changing file name $50. Voluntary cancellation filing fee $50. Certification registration under seal $8.75. Certified copy of the application file $52.50. Alright, these are actually gonna go over the same things. Like this one, these are actually the forms, page directions. These are the forms. You can find them. Pretty much self-explanatory. I will go over them in one section, except for this one.